Hello everyone, this is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to this episode of This Week in FCPA, episode 61 for the week ending July 14, 2017, the Summer in the City edition. This week, Jay and I return for a wide-ranging discussion of some of the week's top compliance and ethics-related stories, including the HSBC Monitor Report is protected from release by the Second Circuit. We consider the Odebrecht scandal and how it continues to resonate across South America. We take a look at the first half of 2017, which brought two final resolutions of only two FCPA matters from the new administrations, both of which were declinations. Both declinations have significantly strengthened the FCPA Pilot Program as a clear path forward for every company that finds itself in FCPA hot water. We take a deep dive into Roy Snell's article about It's Not Who's Who, but Who Gets It, which was published in the SCCE Compliance and Ethics blog. I talk about the rollout of the Compliance Podcast Network. I identify the 8 podcasts which are part of the Compliance Podcast Network, and we have a short discussion of that. Then we talk about the Everything Compliance recording that I had this week in Houston, where both Matt Kelly and Jonathan Armstrong were present, and we piped Jay Rosen in. We talk about some of the topics and preview the debate. This Week in FCPA is part of the Compliance Podcast Network. Thank you very much for listening to this episode. This is Tom Fox, the Compliance Evangelist, back for another episode of This Week in FCPA with my colleague Jay Rosen, Mr. Monitors. We are back for episode 61 for the week ending July 14, 2017, the Summer in the City edition. Jay, welcome.
Hey, Tom. How are you?
I am good. Jay, I'm coming to you today from, indeed, the city of Manhattan, New York City, where I'm here visiting my daughter who is interning this summer.
Are you staying at the Trump Tower?
We are not at the Trump Tower. No, we are not engaged in any ethical violations along those lines. I will note it is 65 and raining, so it is very un-Houston-like weather. But that did not stop the week from having some very interesting ethics and compliance-related stories, Jay. So maybe we can just kind of hop right into it. I'm not sure who broke it, but you, as in you, Jay Rosen, alerted me about a very significant appellate decision that came out this week entitled or regarding the HSBC Bank. And it was not an FCPA case. Nevertheless, it has significant implications in the FCPA realm. And basically, Jay, in this case, HSBC, I think many people know, entered into a deferred prosecution agreement for multiple violations of the Banking Secrecy Act, the International Emergency Economic Powers Act, and the Trading with the Enemy Act, basically money laundering in 2012. As part of that agreement, they agreed to an external monitor who would file periodic reports on HSBC's ongoing compliance with anti-money laundering laws and with the deferred prosecution agreement itself. The monitor would report annually. Certain news organizations filed suit asking for the court to release the monitor's report as a public record. The district court agreed with that somewhat and allowed the parties, the district court, to order certain release of the monitor's report, redacted release, and then HSBC and the government jointly appealed this to the Second Circuit Court of Appeals. The federal district judge was Judge Gleason, and perhaps not surprisingly, the Second Circuit overturned Judge Gleason and said no, that the federal district court could not order release of this because it was not as part of a court's exercise of jurisdiction. And not to go too far into the weeds, Jay, but on the legal side of things, we had known from prior Second Circuit and other Court of Appeals opinions that the prosecutor here at the Department of Justice really has exclusive jurisdiction when deciding on the terms of a deferred prosecution agreement. District court judges have been slapped down and saying that they did not approve of terms for DPAs. But here we had a court saying that in addition to, or on other jurisdictional bases, was when the monitor filed a report after the DPA had been entered into, and the court had jurisdiction over that DPA. And the Court of Appeals said no, the district court does not have jurisdiction over a monitor's report absent extraordinary circumstances. So for those who had hoped that monitor reports would be released, this is certainly goes in the opposite direction. Most interestingly, there was a concurring opinion by one of the three sitting federal judges, and that was Judge Pooler. And Judge Pooler really criticized the DPA process, where he didn't feel that the court had any other way to rule other than the way it did. And he criticized really the use of DPAs and explicitly encouraged the Congress to take a look at this and have them opine, or rather pass legislation which would allow court overview of DPAs, possibly including the release of monitor reports. Now, we've had other judges criticize DPAs before. Certainly, Judge Rakoff has been one of those. But here we have yet another Court of Appeals judge doing that. And whether this Congress, who can't seem to do anything, I would say, other than tie their shoe, but that may even be a stretch, whether they could get together and address some of the concerns that have been raised by the judges around deferred prosecution agreements, I don't know. But this really makes clear from the legal perspective that the DPA and negotiation and settlement process belongs to the prosecutors and the prosecutors only, and the courts have no role in that. So what does kind of the monitor community think about this from your perspective, Jay?
It's a pretty interesting ruling, not from the monitor perspective, but I just as you were reading the story and recounting the events, I kept hearing a little British accent in my ear. Possibly it was our good friend Jonathan Armstrong talking about how under the UK Bribery Act that the judiciary is actually part of the DPA process. So I think it's a legitimate criticism from the government's perspective. I think from the monitor's perspective, we would want to be doing our work with our client, to the government stipulations. And I think that work product is something that should be kept closely held. And, the only thing that could potentially be revealed is if, the company becomes a recidivist or they fall off the wagon. But besides that, I think it is an accurate ruling right now to keep that under wraps.
So we're going to have to watch that one, Jay, because when you have a Court of Appeals judge really inviting congressional scrutiny, that tends to get things moving. Although we've had other judges raise this before. So you raise good points. I can see arguments on both sides, and we'll just have to see how this one will continue to evolve going forward. So next up, Dick Casson wrote a really interesting piece, Jay, in the FCPA blog this week about the continued reach of the Odebrecht scandal. And I think you and I have talked about this before in terms of some of the countries that Odebrecht was in, some of the governments that may have taken Odebrecht money, some of the political fallout in countries other than Brazil. But Dick looked at it really from the angle of fund managers who indicated that Odebrecht demonstrates a danger in what's called frontier markets and shortfalls of corporate governance. And so what we have really is fund managers saying that stock in foreign companies in some of these countries may be negatively impacted by Odebrecht. Now, part of it is obviously the fallout from Odebrecht, but it could include such things as putting other companies under scrutiny. It could be other foreign governments other than Brazil are cutting back on public infrastructure expenditures for fear of being entangled or allegations of bribery around Odebrecht or other countries. It could be that individuals who actually have been now named as receiving Odebrecht corrupt funds are in positions where they simply can't move forward now. But when you have the investor community start saying, hey, people, this makes a difference, and it's reducing the investment advice or the positive investment advice we can give, I really think that, Jay, speaks to a level of how far down this type of scandal has impacted in Latin America. Now, I know at one point in your varied and multifaceted career, you worked somewhat in that space. And so from any of your corporate experiences, when you have these kinds of negative reports from fund managers, how would that really be viewed?
I think you could view it as any type of public information that is withheld that could affect stock prices. And, when we see a lot of these follow-on lawsuits from, corporate attorneys talking about that the company has missed their fiduciary responsibility by not revealing an investigation in a timely manner, a lot of times those get dismissed as nuisance suits. But I still think that, the way our market works, there's lots of assumptions that are priced into stocks, and you need to know whether or not revenue is clean, and if there are other issues, that's the reason why that, when we're always looking at quarterly reports and looking at companies that put aside reserves for investigations or potential payments to the government. So I think, this is a very logical conclusion towards where a situation like Odebrecht might lead.
Well, it's certainly something that I think U.S. investors, U.S. companies, and others are really going to have to keep an eye on, Jay, because we're beginning to see this, really the effects of this multiply down through multiple levels of multiple countries' economies. And I think when you have that kind of effect, it's something that at least needs to be monitored. I have my July article published this week in Compliance Week, and Jay, in it, I took a look at the first two final resolutions on FCPA matters this year under the Trump administration. Of course, they're the Lindy Gas case and the CDM Smith case. And in my article, I take a look at they were both declinations. And I found that they had significantly strengthened the FCPA Pilot Program as a clear path forward for every company that finds itself in FCPA hot water. What I saw in this, Jay, was really an effort by the Justice Department to give substantive credit to companies who meet all four prongs of the FCPA Pilot Program. Now, there has been some critique that I think Matt was a little frustrated with the lack of information that came out in the declinations, and he spoke to that in our recording session for our next episode of Everything Compliance that we'll talk about a little bit later. But I found that, first of all, declinations typically don't have as much information. So I found that to be a structural issue. Nevertheless, I think it's important that the people think about the four prongs of the pilot program. And they think about each step that you have to take, and the requirements are really laid out in the pilot program. Now, we don't know kind of the specific levels of extraordinary cooperation, and the steps of remediation, because those were not revealed in the declination letters. Nevertheless, I think it really gives the compliance program and compliance professions some solid information to move forward on. And when you only have two, of course, everything focuses on those two, and that's what I did in my article. But I found it to be a really important step forward for the compliance professional. And from the compliance program perspective, it's something that you can take a look at. The Justice Department is clearly giving credit to those companies who meet the parameters of the pilot program. And if you find yourself in this situation, it may well be worth your while to self-disclose and remediate and cooperate with the government. And, of course, disgorge ill-gotten gain or profits based upon bribery and corruption. So I think it was certainly a net plus. Whether it was a big plus or not, I'm not quite sure, but it was a net plus for the compliance profession. It's a net plus for compliance programs, and it demonstrates to me that this Department of Justice is going to continue to reward companies who meet the requirements, the four prongs of the pilot program. And if you do find yourself as a compliance professional or as a company in this situation, there is a path forward that you can successfully navigate out of.
A quick question for you, Tom. Two different industries that we're looking at, right? CDM Smith is the construction business. Lindy is gas and, I guess, medical supplies.
Industrial gases.
Industrial gases. So I know that Matt took issue with the fact that there seemed to be a lot of repetition and the reasons why they received the declination. Can you think of anything that could have been or anything that was specific to either industry that stood out in your mind? Or, again, to Matt's point, is it that they satisfied the four prongs and that's what we get back in the declination?
Well, I guess, Jay, I might have to answer it in a little bit different manner because it was the things that were kind of specific to those industries were the bribery schemes. And that may not even be correct. It may not have been specific to those industries, but they were certainly interesting bribery schemes. And whenever you can have the bribery scheme itself discussed, even in a couple of sentences, that gives people like you and I information to help communicate to our clients about, hey, have you looked for this? Have you put internal controls in place to protect against this? Certainly in Lindy Gas, what due diligence did you do in pre-acquisition? What due diligence did you do post-acquisition? Because that involved a case where the acquired company engaged in bribery and corruption. They did not begin until after Lindy Gas had acquired them. So, I can't even say that it was the acquired company because it was Lindy Gas that did the bribery and corruption after they acquired the company. They're no longer them; they're now you. And so there were numerous lessons that could be drawn from the specifics of the bribery scheme. But as to the other point you raised, I'm not sure that I saw anything industry specific with regard to the application of the pilot program or the companies following the prescripts of the four prongs of the pilot program.
Thanks. The other thing we can keep in mind is I remember when I was a wee lad in the FCPA land, and I always used to hear you talking about opinion release number something point something. And a long time ago, you really had to search through a DPA or an NPA, and you really had to figure out what DOJ or what SEC was responding to. And in those intervening years, we've had the guidance, we've had the new document that Way worked on. So it's possible maybe with even, much to Matt's consternation, if we bring up this point about the declinations, who knows what will come in further decisions this year or in the future, but maybe DOJ might see the wisdom in, being a bit more expansive in the reasons why the company achieved their declination.
Could well do so, Jay. We should also note, or I should also note that this is now the sixth declination. There were 4 in 2016 and 2 this year. So these are posted on the DOJ website. Certainly, I blog about them and talk about them, and I think we link to my Compliance Week article where I wrap all this together for the compliance professional going forward. So, Jay, we had a interesting article from Roy Snell. So why don't you, with that with me giving that limited introduction, you had some really interesting comments on it. Why don't you set it up and kind of lead us into this part of the podcast?
Thanks, Tom. So I guess yesterday Roy had an article that appeared on the SCCE, the Society of Corporate Compliance and Ethics website, and it was entitled "Who's Who versus Who Gets It?" And it seems that as of late, with ethically what's happening in this country, there are a lot of Johnny-come-latelys who are showing up with, large public personas or having worked on a marquee case and trumpeting that they are ethics and compliance professionals. And Roy, as he often does, this got a little bit under his skin and raised his hackles, and he got out there and wanted to talk about the difference between somebody who just flaunts their ethics and compliance bona fides and somebody who lives it and does it each day. And he spoke about a few of our colleagues who we know very well from the conference circuit. He mentioned Christy Grant Hart. He mentioned our colleague Jonathan Armstrong, Samantha Greaves, Al Gagney. And these are people who have all been through companies and they understand what we're up against. I decided to retweet Roy's article, and I said that E&C practitioners are ones who live and breathe ethics and compliance 24/7, 365. And Roy was kind enough to pick up that idea and use that as a subtitle into his piece. And I think as of right now, I've had something like 1,300 people who have looked at our article since actually it's now at, hang on one sec. It's now at 1,606. So it seems to have struck a nerve with other folks in the SCCE and the ethics and compliance community, and wondering what your thoughts are.
So I certainly agree with the sentiments. I guess really from my perspective, I think the quality of information that you put out is key. Have you put out things that specifically help the compliance practitioner, the compliance community, the chief compliance officer moving forward? And it doesn't really matter to me if you started doing that yesterday or you started doing that 10 years ago. If you don't put out any information that's helpful or useful and just want to engage in polemics around ethics and compliance, that's of no use to the compliance community. But it's putting out useful, helpful information around this that I really find that is the most important thing. And the people Roy named, I guess, other than perhaps Christy Grant Hart, who Roy notes does have one of the great names of all time when you can have the hyphenated name. That's very cool. And of course, she lives in England, so it's even more appropriate. She is communicates, writes, it certainly speaks a lot. But some of these other folks, Greg Tribuga, Samantha Greaves, Kim Lansford, Al Gagney, Dwight Closter, Jonathan Armstrong, Linda Hillard, Kathleen Grilly, Erden Anderson. Those people are not writing as much. Nevertheless, when they do put something out there, it's useful, it's substantive, it's communicated in a way that is not an attack, but it's positive, useful information. And really that's kind of what I drew from Roy's point. And the reason I name those people is those are not people who blog every day. Those are not people who podcast every day, although I know Jonathan does some podcasts for his firm, and he's certainly a part of our Everything Compliance group. But we both know Samantha quite well, and she occasionally publishes an article. And it's certainly a quality article and certainly very useful. Erden Anderson, I've heard speak several times, and very insightful, very useful information for the compliance profession. So I guess the point that I really drew from Roy, even if it wasn't precisely what he intended, was that it's not the the length of time that you've been doing it, even if you're Johnny come lately, if you've got some substantive information that's quality information, that's useful information for the compliance professional, the compliance profession, that's what we need to have out there. Just polemical debate over what's ethical or what's not is useless and not needed.
Well said.
So we're going to link to this article. It's, as you said, Roy really got going on this one. We'll link to it in the show notes. So we hope people will continue to check it out.
So how about Monday's blog of yours? Can you tell some of our listeners about that?
Sure. So Monday, July 10th, the day after my birthday, I rolled out the Compliance Podcast Network. And I'm really thrilled to roll this out. It is the first podcast network dedicated to compliance. It has, I think, 8 different podcasts that I produce. And some of them I am a participant. In some of them I am a moderator. In some of them I'm a host. So it puts, and I have 4 platforms that I put these podcasts out on. It includes certainly my site, FCPA-Compliance-Report.com, iTunes, Libsyn, and JD Supra. The podcasts are, of course, this podcast, This Week in FCPA, where Jay Rhodes and I review the week's ethics and compliance and FCPA stories. The FCPA Compliance Report, where I interview a person on a relevant topic around compliance. The Compliance Report International Edition, where I interview someone from outside the United States. 12 O'Clock High is a podcast on business leadership. On that podcast, I'm hosted by my colleague Richard Lummis, and I comment on business leadership issues. Unfair and Unbalanced, a podcast with myself and Roy Snell. Compliance Into the Weeds, a podcast with myself and Matt Kelly. Across the Board, it's a new podcast I'm debuting next week, Jay, where I take a look at compliance, corporate governance, and the role of a board of directors and generally in risk management. Obviously, everything compliance that we're going to talk in a little bit more in detail in a minute, which is a roundtable podcast of yourself, Matt Kelly, Jonathan Armstrong, and Mike Volkov. And then finally, I do a daily podcast on 1 month to a more effective compliance program, where each month I take a different topic and take a deep dive into the specific issue. This month it's internal controls, but I've investigated investigations, the role of HR, human resources and compliance, board of directors, and really I've enjoyed that. That podcast is 10 to 15 minutes each day, where the compliance professional can learn one thing on one topic and give them 3 key takeaways at the end that they can incorporate into their compliance program that day. So that's the Compliance Podcast Network. It is on 4 different platforms. It's available for download if you want to timeshare and listen to it later. Of course, it's all free. And it's really my effort to bring the most, widest, deepest, and best knowledge to the compliance professional on topics that are useful to them moving forward in compliance.
Well, I think it's an outstanding undertaking, and I hope people avail themselves to it. And it's nice to have all this information together in one place so it can be easily accessible. So, Jay, I thought maybe we would end this week with a little tasty preview of the Everything Compliance, next couple of Everything Compliance podcasts. We had the opportunity this week. Jonathan Armstrong and Matt Kelly were both in Houston. So I got us some studio time, and we were able to pipe you in to have a 3-way. It was not the 4 amigos this time. It was the Trace Amigos. Nevertheless, we had a really interesting and I thought very fun podcast where we took a look at a wide variety of issues. Some of these included the Trump administration and FCPA enforcement, the EU's GDPR, Wei Chen's departure from the Department of Justice, the Walter Schaub's departure from the Office of Government and Ethics, the enforcement reports in FCPA that we touched a little earlier, but highlighted in the Gibson-Dunn FCPA mid-year report. We took a look at briefly campaign finance laws,
the right to be forgotten. In Europe, big data and compliance, what it might mean for antitrust in Europe. Jonathan took us through 6 years of the UK Bribery Act and talked about the Rolls-Royce prosecution and why it was so significant. So it really, I thought was, and then I, of course, talked about my current most favorite subject, the Chicken Shit book, the Chicken Shit Club book. Sorry, once again, we will, of course, announced in the introduction of adult language in this. It was really a wide-ranging, long podcast, and everybody got to do a good rant at the end. So I think people are going to enjoy it, and it was really a ton of fun, Jay. Yeah,
it certainly was. Are you going to release both halves next week, or one half next week and one half the week after?
It'll probably be, we went pretty close to 2 hours, so I'll do 2 1-hour podcasts. Probably the first half will be yourself and Matt, and then Jonathan and myself. But we'll get the rants in on the first podcast because they were a lot of fun.
So, question about your reading habits. Are you a Kindle guy, or are you still reading on real paper that you can put between your fingers?
No, I'm a book and paper guy.
So did you get to jump into any of your new favorite book on the flight to New York?
I jumped into the Chicken Shit Club.
And any little teasers you can give us right now, or do you need to read more before you can give us a nugget? The thesis of the book is why the DOJ has dropped off its number of prosecutions of individuals around corporate white-collar crime. The last significant prosecutions were the Enron, WorldCom, and from that era of financial fraud. And after that, it's dropped off pretty considerably. And so I read up through the Enron trials, and I just got through the Arthur Andersen case. And it really turns out that Arthur Andersen was the seminal event which crystallized the change in DOJ policy. For the listeners who might not remember, Arthur Andersen was Enron's auditors. They were caught destroying documents, and they went to trial, refused to take a guilty plea in settlement, went to trial, and lost at trial, and lost. The company ended up disintegrating and going away. Arthur Andersen had that case reversed at the U.S. Supreme Court. So at the end of the day, they won. The problem was there was nothing left. But what Arthur Andersen did win was the battle of public opinion. And they hired a PR firm that put on a very interesting and for that time new and aggressive PR program that it really wasn't fair to put a company out of business for the action of a few bad apples. And that by aggressively enforcing U.S. laws, the Department of Justice literally put a multi-thousand employee company out of business. And that storyline is something that really I believe was true. It turns out that Arthur Andersen was really on its last legs anyway. They made a series of major problems, a series of major malpractice cases. And so whether or not they would have gone under absent Enron is unknown, of course, at this point. But the story became that was what took them down. And that story resonated with people like me. It resonated in the business community. The business community lobbied Congress. They lobbied the Department of Justice not to let this happen again. I think if you talk to DOJ prosecutors after that time, they were certainly cognizant of that. And I don't think they would say they were in the business of putting out companies out of business that were not, complete evil empires. There are some companies that are like that, that are evil empires. I don't think Arthur Andersen was an evil empire. Nevertheless, they did go out of business. So the fallout from Arthur Andersen, and most specifically the PR campaign they put on after they lost at trial, but were still around on appeal, they won that battle. And that's where I am in the book. So it's going to be interesting to see going forward. It's very well written. The Chicken Shit Club by Jesse Eisiger.
So pick it up, and at some point I'm going to do a very lengthy podcast on it with someone. So we'll have to see how that goes.
Great. Well, thanks for sharing where you are in the book, and hope you have fun with your daughter this weekend. On behalf of Tom Fox, the compliance evangelist, and myself, Jay Rosen, Mr. Monitor, we'd like to thank you for spending some time with us and looking at This Week in FCPA for the week ending July 14th, 2007, Bastille Day.
This is Tom Fox again. I'd like to thank you again for listening to this episode of This Week in FCPA. If you have any questions, you can email me at tfox@tfoxlaw.com. You can email Jay at jrosen@affiliatedmonitors.com. Also, if you listen to this podcast on iTunes, it would greatly appreciate it if you would rate our podcast, as it would help in our rankings and help get the word out about the only weekly summary of the FCPA and compliance-related events. This is Tom Fox. Thank you again for listening, and I hope you'll join us next week for another episode of This Week in FCPA.